It took 2+ months after the murder of Ahmaud Arbery for police to arrest the men responsible, 74 days. Not because they didn't know who they were or where to find them, but because local officials in Georgia repeatedly told officers not to go after them. That was until a video of the attack was posted online, and now, well over a year and a half later, all three white vigilantes who chased him down have been convicted of his murder, facing up to life in prison with no parole.
This is the second Thanksgiving that my family and I will share without Ahmaud. But this is the first Thanksgiving that we can look at that empty chair and say, we finally got justice for you.
It won't bring Ahmaud back, but we do know those guys be accountable for the lynching that they done to him.
The three are also expected to stand trial on federal hate crime charges in February. And on the same day that verdict came, the then DA who first helped shield them turned herself into police. Jackie Johnson was indicted last month for obstructing police and showing favor and affection to the killers, one of whom was a former police officer she worked with as DA. And in another case of violence inspired by hate, this one from the 2017 Unite the Right rally in Charlottesville, Virginia, a jury has found that James Fields, a white supremacist who drove his car into the crowd, killing 32-year-old Heather Heyer, was liable for more than $25 million in damages, along with several fellow white supremacists who organized that event. Fields was already convicted of murder and sentenced to life behind bars. Of course, both of those decisions came just days after Kyle Rittenhouse was spared any accountability for shooting and killing 2 people and wounding a third at a Black Lives Matter protest in Kenosha, Wisconsin last year. So is there a broader message from these cases than the verdicts themselves? Joining me to discuss are Ron Sullivan. He's a Harvard law professor and director of the Criminal Justice Institute at Harvard. He helped the family of Michael Brown win a $1.5 million settlement from the city of Ferguson, Missouri, and Boston Globe columnist and associate editor Renée Graham. Renée and Ron, thank you for your time. I appreciate it.
Thank you.
Thank you.
Renée, if I can start with you, does the conviction of the 2 McMichaels and Bryan have any impact beyond the walls of that courtroom and the family and friends of Ahmaud Arbery?
I mean, this was an important verdict, but it's also one verdict in one case. It's not a turning point, and it's not a reckoning. And I think we should just retire that word forever. The fact that its outcome was in doubt until the moment the judge announced that McMichaels and William Bryan were found guilty does not speak highly of a system in which so few people have faith or expect accountability. As you mentioned, it took 74 days before the McMichaels were charged with murder. And if not for that videotape, there probably wouldn't have been a trial at all.
You know, I have to say, Ron, I think the conclusion that Renée is describing is the consensus I've heard. But on the other hand, if one believes the acquittal of Kyle Rittenhouse was a win for vigilantism, I assume one has to believe that the conviction of these 3 men was a loss for vigilantism. But I guess then the issue is, does that loss spread its tentacles beyond this case? Does it?
Well, that's the important question, and I agree with the previous speaker. So it is a win, but I think we have to view it in moderation. It's doesn't represent a systemic change, but to say there's no difference between Emmett Till and now would be untrue. It would be to disregard history. So we now have an example of white jury, predominantly white jury, in a southern state convicting white people for killing Black people. That was unthinkable years ago, and I, like many, was unsure it was going to happen this time. But it is a step in the right direction, but we do have to remain vigilant because the system as a whole still is deeply flawed and problematic.
I mentioned the Rittenhouse case. Renée, you wrote, if Rittenhouse were Black, his tears would have gotten him nowhere, obviously referencing Rittenhouse crying on the stand during his testimony. And Ron, you wrote, if Rittenhouse had been Black, he most assuredly would have been convicted. Starting with you, Ron, why'd you say that?
Well, I say that because I believe that the jury would have viewed the discretionary elements quite differently than it did with if the defendant had been Black. So one thing the jury in Rittenhouse had to decide was whether his use of force was reasonable in light of all the circumstances. I believe, based on the history of this country, that if a Black person had rifled down white people, they would have had questions. The jury would have had questions as to whether that was a reasonable use of force. The second big question was whether it was a provocation. Both of those were resolved in favor of Rittenhouse, and reasonably so, I think, given the evidence. I think it would have gone in the other direction had the defendant been black.
Renee, if Rittenhouse were black, why would his tears have gotten him nowhere?
I just don't think this country is terribly empathetic towards Black people. I also don't think if Rittenhouse were Black, he would have gotten out of Kenosha that night. There wouldn't have had to be a trial because he would have been shot dead in the street. It's just the nature of the way things work. And I think that the way the trial went with Rittenhouse, you sort of noticed how there was this attempt made constantly on the part of his defense team to infantilize him. He was just a child. He was just a kid. He was this 17-year-old boy. No 17-year-old Black child is ever treated that way. Trayvon Martin was 17 years old. And what did George Zimmerman say to his parents? I thought he was older. I thought he was a few years younger than I was. George Zimmerman was almost 30 years old. So that's what kind of happens. And that's why I do not believe that a jury would have looked at a 17-year-old child and believed his tears or believed, in fact, that he was a boy who made a mistake.
Do you agree with Ron, Renee, that had Rittenhouse been Black, he would have been convicted?
Oh, absolutely. Oh, no question about it.
Ron, you raised another issue.
If he had survived to get to a trial. Let's say if he had survived to get to a trial.
You also wrote in that same piece, Ron, assuming the Black defendant would have been guilty, what does it say about the Rittenhouse verdict? What does it say about the Rittenhouse verdict, that it's totally a function of the color of his skin?
Well, no, that's not the point I was driving at. The point I was driving at is that's a true proposition, I believe, and I believe it wholeheartedly, and I believe that chunks of the Black community believe that as well. I don't think we take that to say that Rittenhouse should receive less justice. That was not a great case for the government. The reason it wasn't a great case for the government is because Wisconsin had a set of laws that permits a 17-year-old to parade around with a semi-automatic rifle lawfully. That, to me, is the big problem here. I think the jury, I think that was a self-defense case, given the law of Wisconsin and given their open carry laws. But we shouldn't say, hey, because a Black person would have been convicted, let's convict Rittenhouse too. No, what we should insist on is that each and every defendant be treated like Rittenhouse, not Rittenhouse be treated like poor Black defendants. So I think level up, not level down, is the point I was trying to make with
Understood.
that.
Can we do one more what would have happened if for a second? Let's return, if we can, for a minute to the McMichaels and Bryan. There was a pretty critical moment during the cross-examination of Travis McMichaels himself. I'm sure people have seen it, but I want to show it again.
And at this point in time, when you first see him on Burford, he's not reaching into his pockets.
No, ma'am. Not running, no, ma'am.
And he never yelled at you guys?
No, ma'am.
Never threatened you at all?
No, ma'am.
Never brandished any weapons?
Sorry, Your Honor, he's trying to finish his answer.
Yeah, he did not threaten me verbally. No, ma'am.
All right. Didn't brandish any weapons?
No, ma'am.
Didn't pull out any guns?
No, ma'am.
Didn't pull out any knife?
No, ma'am.
Never reached for anything, did he?
No.
He just ran?
Yes, he was just running.
Ron Sullivan is a big-time criminal defense attorney. As quick as the verdict was, I think 4 hours, the jury was out. Without that incredible cross-examination, is it clear to you that these three men would have been convicted of murder?
Well, I don't know about the cross-examination. It was great. It's pretty clear to me that without the videotape, it would have been a really tough road for them to get a conviction. So the videotape limits what they could say because it's right there on tape. What was most disgusting to me about that is that they were even allowed to offer the defense. You know, Jim, you remember the burden of persuasion from law school. You've got to reach a certain level to even put a defense on. And listening to that cross-examination, my goodness, how can you even claim self-defense given those facts from the defendants themselves? You know, Renee, we started this discussion by me asking you about what you thought the impact of the conviction of the McMichaels and Bryan was beyond the Arbery matter, the murder of Arbery himself.
my take is the most significant and potentially farthest reaching impact of any of these cases was neither of the criminal trials, but was the civil trial in Charlottesville, Virginia, of the men who inspired the Unite the Right rally, $26 million in damages. Am I naive to think that when there's that kind of financial pain visited on people who incite such things, that it will cause others to think twice before they do the same thing?
I think it might cause a few people to think twice. I don't know that it will have the kind of blanket effect you might think that a $26 million settlement would have on people's consciousness. I think in all of these cases, there's a sense that, well, the McMichaels are going to go away and Bryan is going to go away and these people will owe this settlement, but that's not going to happen to me. I think people who are driven by these white supremacist motives are not going to be swayed by these outcomes.
Do you, Ron Sullivan?
I think it's much more of a specific deterrence than a general deterrence. This is a playbook, play right out of the book of Morris Dees and the Southern Center. One by one, bankrupt specific organizations so that those specific organizations and individuals can no longer do harm. People with such malice in their hearts, no, I don't think there's going to be, they're not thinking like that. Oh, I'm afraid of getting sued. But sue each of them individually, get these big verdicts, and one by one, reduce the number of hate groups in the country.
Renee, if it's not going to have the kind of impact that I hope it does, are we just destined to live through Groundhog Day forever, or at least for the foreseeable future with all this kind of stuff?
I mean, we've had 400 years of Groundhog Day, so probably. But I do think accountability is important. I do think that these trials serve a purpose and that the people who do wrong are held accountable. That's all we ask for. Justice would, of course, be if this doesn't happen at all. But when these things do happen, you have to have accountability. And at least in these two instances, that's what we saw last week.
How do we get greater or broader accountability, Ron, that goes beyond individual cases? Law change, cultural change, thinking, what is it?
I think all of the above, but one of the things we have to do is get law change. And, I'm a lawyer, I'm a law professor, so this is an area that I know a lot about. I'll leave the cultural change to my friends over at the Divinity School. But in terms of law, positive law, we have to begin to elect people who reflect our values, and so that they will put laws on the books consistent with those values. You may or may not like me, but the law will insist that you treat me in a particular way or else be held accountable. I think that's the cleanest way out of this conundrum that we find ourselves in.
And do you see that happening, or is that pipe dream stuff?
Look, I do. Maybe I'm an optimist, but look, there's something different between the era when Emmett Till was tried and now. Obviously and indisputably so. We've moved in a positive direction. There is a lot. I mean, the association of color and criminality, or color as a proxy of criminality, still infects this country to its very core. But we are getting better. Slowly, but surely we are getting better. We can't take our foot off the gas, though. We have to keep insisting that we behave in a different sort of way. I think it's doable. I think it's got to be doable, or else we're going to destroy each other.
Only have 30 seconds, Renee. Do you share that? I'll describe that as optimism. Do you share Ron's view?
For me, the only difference between the acquittal of Roy Bryant and J.W. Millam in the murder of Emmett Till in 1955 and the conviction of the McMichaels and William Bryan last week in the murder of Ahmaud Arbery is technology. Without the videotape, there would have been no trial.
Renée Graham, Ron Sullivan, thank you so much for your time. I really appreciate it.
Thank you, Jim.